Jai Hind everyone. I'm Dr. Akash Kumar from the Department of Applied Science Humanities at Kumar Engineering College, Ghaziabad. Would be taking a lecture on the subject of Constitution of India, Law and Engineering, and the topic for the day is Laws at Workplace. The lecture will be proceeding with these following points. We'll just discuss some introduction. Then we discuss the number of acts and laws such as Factory Act 1948, Industrial Employment Standing Order Act 1946, Contract Labor Regulation and Abolition Act 1970, the Employees Compensation Act 1923, Weekly Holidays Act 1942, and we'll finally conclude the lecture with discussing the Maternity Benefit Act 1961 and Sexual Harassment of Women Employee at Workplace Act 2013. Let's go into the detail of the introduction. Industrialization is concerned as to be one of the key engines to support the economic growth of any country. The commence of industry and its growth is not a venture of employer alone, yet it involves the hard work and tough grind of each and every stakeholder of the industry, including the laborers, supervisors, managers and entrepreneurs. A plethora of labor laws have been established to ensure elevated health, safety and welfare of workers, just to protect workers against oppressive terms as individual worker is economically weak and has little bargaining power, to encourage facilitate the workers in organization, to deal with industrial dispute, to enforce social insurance and the labor welfare schemes and alike. This we have just discussed the background, why it is necessary to look into the various laws and acts just to define the welfare zone of the individual employee. First we go into the details of the Factory Act 1948. The Factory Act 1948 lays down provisions for the health, safety, welfare and service condition of workmen working in the factories. It contains provisions for working hours of adults, employment of young persons, leaves, overtime, etc. It applies to all factories employing more than 10 people and working with the aid of power, or employing 20 people and working without the aid of power. It covers all workers employed in the factory premises or presents directly through an agency, including a contractor involved in any manufacture. Some provisions of the Act may vary according to the nature of the work of the establishment. Some major provisions of the Factory Act, just we'll go through some minor details, such as the first point is the section 11 of the Act provides that every factory shall be kept clean and free from effluvia arising from any drain, privy or other nuisance. Section 13 of the Act focuses on the ventilation and temperature maintenance at workplace. Every factory should work on proper arrangement for adequate ventilation and circulation of fresh air. Section 18 of the Act specifies regarding arrangements for sufficient and pure drinking water for workers. Section 19 of the Act further mentions that every factory there should be sufficient accommodation of urinals, which should be provided at conveniently situated places. It should be kept clean and maintained. Section 21 of the Act provides a proper fencing of machinery, and that any moving part of the machinery or machinery that is dangerous in kind should be properly fenced. Further, the section 45 of the Act specifies that every factory should have a properly maintained and well equipped first aid box or cupboard with the prescribed content. Every for every 150 workers employed at one time, there shall not be less than one first aid box in the factory. Also, in case where there are more than 500 workers, there should be well maintained ambulance room, prescribed size and containing proper facility. So, we have just looked into the details and we just have got a glimpse that mainly the factory has deals at the first level with the provision of the hygienic conditions to the workers at workplace. Next, the Industrial Employment Standing Orders Act 1946. The Industrial Employment Standing Order Act 1946 is applicable to every industrial establishment wherein 100 or more workmen are employed or were employed in any day of the preceding 12 months. The Industrial Employment Standing Order Act aims mainly to bring uniform terms and conditions of service in various industrial establishments. The IESO Act requires every employer in an industrial establishment to clearly define and publish standing orders with respect to conditions of the employment, service rules, and to make them known to the workmen employed by it. The Act further specifies that every employer is required to submit to the certifying officer 5 draft copies of the standing order which he intends to adopt for his establishment. Next, we have the Contract Labour Regulation Abolition Act 1970. The main objective of the Contract Labour Regulation and Abolition Act 1970 are as follows: to prohibit the employment of contract labour, the first one. The second one, to regulate the working conditions of the contract labour wherever such employment is not prohibited. The Act defines a worker as a workman who shall be deemed to be employed as a contract labour in or in connection with work of an establishment when he is hired in or in connection with such work by or through a contractor with or without the knowledge of the principal employer. The Contract Labour Act regulates employment of contract labour in certain establishment and provides for its abolition in certain circumstances. It applies to every establishment or contractor wherein with whom 20 or more workmen are employed or were employed on any day of the preceding 12 months as contract labour. The government may, however, by notification in official gazette, may the provision of the Contract Labour Act applicable to establishment or contractor employing less than 20 workmen, and this act is not applicable to establishment in which work only as an intermittent or casual nature is performed. The Act prevents exploitation of contract labour to provide proper habitual working condition, to regulate the functioning of the advisory board, to lay down the rules and regulations regarding the registration procedure of the establishment employing contract labour. So the important fact here we must build up understanding that this act, Contract Labour Act, basically looks into the working condition related to the laws, related to the provision of various amenities to them, treating them as a contract labour and looking into the nature of their work and trying to provide them the better facilities and working conditions, because since they are not the permanent workers, so therefore there has to be some mechanism which should look into the should address their working conditions. Employees Compensation Act 1923, formerly known as the Workmen Compensation Act 1923. Employees Compensation Act 1923 aims to provide financial protection to workmen and their dependents in case of any accidental injury arising of or in course of employment and causing either death or disablement of the worker by means of compensation. This act applies to the factory, mines, docks, construction establishment, plantation, oil fields and other establishment listed in Schedule 2 and 3 of the said act. But it excludes what? It excludes the establishments covered by the ESI Act, Employee Security Act, Safety Act. The Act provides for payment of the compensation by the employer to the employees covered under this Act for injury caused by accident, and generally the companies take insurance policies to cover the liability under this Act. Weekly Holidays Act 1942. The Weekly Holidays Act 1942 provides for the grant of weekly holidays to persons employed in shops, restaurants and theatres. The Act provides that every shop shall remain entirely closed on one day of the week, which day shall be specified by the shopkeeper in a notice permanently exhibited in a conspicuous place in the shop. Further, the state government may require in respect of the shop or any specified class of shop that they shall be closed at such hour in the afternoon of one weekday or every week in addition to weekly day off. Trade Union Act 1926. The trade union is a voluntary organization of workers pertaining to a particular trade, industry or company and formed to promote and protect the interest and welfare by collective action. They are the most suitable organizations for balancing and improving the relations between the employer and the employee. This is important to be understood why the trade union acts are, why the trade unions are formed. They are formed not only to cater the workers' demand, but also for inculcating in them the sense of discipline and responsibility which defines the way and avenues of growth and development and sustainability of the organization and people at large. The Trade Union Act 1926 deals with the registration of trade unions, their rights, their liabilities, responsibilities, as well as ensure that their funds are utilized properly. It gives legal and corporate status to the registered trade unions. It also seeks to protect them from civil or criminal prosecution so that they could carry on their legitimate activities for the benefit of the working class. The Act is applicable not only to the Union of Workers but also to the Association of Employers. It extends to whole of India. The Payment Wage Act 1936. The Payment Wage Act 1936 is a central legislation which has been enacted to regulate the payment of wages to workers employed in certain specified industries and to ensure a speedy and effective remedy to them against unauthorized deductions or an unjustified delay caused in paying wages to them. It applies to the person employed in a factory, industrial or other establishment, whether directly or indirectly, through a subcontractor. Now, what is the main objective of this Payment of Wages Act? The main objective of the Act is to eliminate all malpractices by laying down the time limit or the time frame and the mode of payment of wages, as well as securing that the workers are paid their wages at regular interval without any unauthorized deductions. In order to enlarge its scope and provide for more effective enforcement, the Act has been empowering the government to enhance the ceiling by the notification in future. Ceiling is said to be the limit, the upper limit or the minimum limit we can say. The importance is that the wages to the workers should be paid so that they can sustain their living. The basic needs they can fulfill by those wages. The Act extend to the whole of India. Minimum Wages Act. The Minimum Wages Act empowers the government to fix minimum wages for employees working in a specified employments. It provides for review and revision of minimum wages already fixed after suitable interval not exceeding 5 years. That means after every 5 years, these wages, the minimum wage is required to be again redefined according to the prevailing inflationary phenomena and then other various policies of the government. It extends to the whole of India and applies to scheduled employment in respect of which minimum rates of wage have been fixed under this Act. The appropriate government shall fix the minimum rate of wages payable to employees employed in a scheduled employment. It may review at such intervals not exceeding 5 years the minimum rate of wage so fixed and revise minimum rates at if necessary. The employer shall pay to every employee in a scheduled employment under him wages at the rate not less than the minimum rate of wage fixed under the Act. The Act also provides for regulation or working hours, overtime, weekly holidays, overtime wages. Period and payment of wages and deduction from wages are also regulated through this Act. The Act provides for the appointment of authority to hear and decide all claims arising out payment less than minimum rates of wage or any other monetary payment due under the Act. The presiding officer of the Labour Court and Deputy Labour Commissioner are the authorities appointed for the purpose. Equal Remuneration Act. In order to ensure this, the Government of India has taken several steps for creating a congenial work environment for women workers. A number of protective provisions have been incorporated in the various labour laws to give effect to the constitutional provisions and also ensure the enforcement of ILO Convention, International Labour Organization Convention. The Equal Remuneration Act 1976 was enacted by the Parliament. The implementation of the Equal Remuneration Act 1976 is done at two levels. Now, what are those levels? One, the central sphere. The Act is being implemented by the central government. In the state affairs, the implementation rests with the state government. The Equal Remuneration Act 1976 provides for the payment of equal remuneration to men and women. No discrimination can be done. Workers and for the prevention of discrimination. We have just discussed this topic. On the ground of sex against women in the matter of employment and for the matters connected therewith or incidental thereto. The Employee Compensation Act 1923. The Employees Compensation Act 1923 is one of the important social security legislation. It imposes security liability upon an employer to discharge his moral obligation towards his employees when they suffer from physical disabilities and diseases during the course of employment in hazardous working conditions. The Act provides for cheaper and quicker mode of disposal of dispute relating to compensation through special proceeding than possible under civil law. The Act provides for the employers liability for compensation in case of occupational disease or personal injuries and prescribes the manner in which his liability can be ascertained. Amount of compensation is payable in the event of an employee meeting with an accident resulting into temporary or permanent disability or disease as stated in Schedule 2 and 3 in terms of Section 4 of the Act. Read with Schedule 4, compensation shall be paid as soon as it falls due. Employees State Insurance Act 1948. The law relating to the employees state insurance is governed by the Employees State Insurance Act 1948. The objective of the act is to provide for certain benefits to employee in case of sickness, maternity and employment in injury, and to provide for certain other matters in relation to thereto. This act is applicable to all factories, including factories belonging to the government other than seasonal factories. The appropriate government may, after giving a notice of not less than 1 month and by notification in the official gazette, extend the application of the act or any of them to any other establishment or class of establishments, industrial, commercial, agriculture or otherwise. Once the act become applicable, it shall continue to apply irrespective of the reduction in number of employees or cessation of manufacturing process with the aid of power. The Employees State Insurance Act 1948 authorizes central government to establish Employees State Insurance Corporation for administration of the employees state insurance schemes. Such corporations shall be a body of corporate having perpetual succession and a common seal and shall sue and be sued by the said name. The insured person, their dependents are entitled to various benefits on prescribed scale. Right to receive benefit is not transferable and assignable. When a person receives benefits under this act, he is not entitled to receive benefit under any other enactment. The act empowers the state government to constitute an employee insurance court. An employee insurance court has jurisdiction to adjudicate disputes, namely whether any person is an employee under the act, rate of wage contribution, as to who is or was the principal employer, right of the person to any benefit under the act. Employees Provident Fund and Miscellaneous Provision Act 1952. The Employees Provident Fund and Miscellaneous Provision Act 1952 is a welfare legislation enacted for the purpose of instituting a provident fund for employees working in the factory and other establishment. This act aims at providing social security and timely monetary assistance to industrial employees and their families when they are in distress and or unable to meet family and social obligations, and to protect them in old age, disablement, early death of the breadwinner, and in some other contingencies. This act is applicable to the factories and other classes of establishment engaged in specific industries, classes of establishment employing 20 or more persons. The central government is empowered to apply the provisions of this act to any establishment employing less than 20 persons after giving not less than 2 months notice of its intent to do so by a notification in the official gazette. Presently, the following 3 schemes are in operation under the act. What are these? The Employees Provident Fund Scheme 1952, the Employees Deposit Linked Insurance Scheme 1976, and lastly the Employees Pension Scheme 1995. The Payment Gratuity Act 1972. In case of Gratuity Act 1972 is one of the important law that makes certain industries pay one-time gratuity to retired employees. The law applies to railways, port, factories, oil fields, plantation, mines and shops. It is an old age retrial social security benefit. It is a lump sum payment made by an employer to an employee in consideration of his past services to the organization. In the case of employment coming to an end due to retirement or superannuation, that is regular payment made into a fund by an employee towards a future pension, it enables the affected employee to meet the new situation, which quite often means a reduction in earning or even total stoppage of earnings. In the case of death of an employee, it provides much needed financial assistance to the surviving members of the family. The gratuity schemes therefore serves as an instrument of social security, and their significance in a developing country like ours, India, where the general income level is low, cannot be overemphasized. The Act is applicable to every factory, shop, or an establishment in which 10 or more persons are employed or were employed in any day of the preceding 12 months. A shop or establishment to which the Act has become applicable shall continue to govern the Act by the Act even if the number of person employed falls below 10 at any subsequent stage. The employee is eligible for receiving gratuity payment only after he has completed 5 years of continuous service. This condition of 5 years is not necessary if the termination of the employment of an employee is due to death or disablement. The maximum amount of the gratuity payable is rupees 20 lakhs. Each employee is required to nominate one or more member of his family as defined in the Act, who will receive the gratuity in the event of death of the employee. Any person to whom the gratuity amount is payable shall make a written application to the employer. The employer is required to determine the amount of gratuity payable and give notice in writing to the person to whom the same is payable and to the controlling authority by specifying the amount of gratuity payable. Now, this paragraph looks into the procedure of how the gratuity amount can be availed by the members of the family or the member himself. Interest at the rate of 8% per annum be paid by the employer if the payment is made within 4 weeks. Failing with the rate of interest would be payable at the rate of 10% per annum. Now, this is the penalty. This paragraph looks into the penalty or the penalty to be applied if the concerned organization does not pay on time. Maternity Benefit Act 1961. Under the Maternity Benefit Act 1961, women employers are entitled to maternity benefit at the rate of average daily wage for the period of their actual absence from 12 weeks to 26 weeks due to delivery. In cases of illness arising due to pregnancy, etc., they are entitled to additional leave with wage for a period of 1 month. They are also entitled to 6 weeks benefit in case of miscarriage. The Maternity Benefit Act 1961 provides that every woman entitled to maternity benefit shall also be entitled to receive from her employer medical bonus. It also makes certain other provisions to safeguard the interest of pregnant women workers. Maternity Benefit Act 1961 regulates employment of the women in certain establishment for a certain period before and after childbirth and provides for maternity and other benefits. This act provides the job of the female worker during the pregnancy and post delivery. Such benefits are aimed to protect the dignity of motherhood by providing for the full and healthy maintenance of the woman and her child when she is not working. Maternity benefit means the payment referred to in subsection 1 of the section 5. The employer shall not knowingly employ a woman in any establishment during the 6th week immediately following the day of her delivery, miscarriage, or medical termination of pregnancy. Every woman shall be entitled to, and her employer shall be liable for, the payment of maternity benefit at the rate of average daily wage for the period of her actual absence, that is to say, the period immediately preceding the day of her delivery, the actual day of her delivery, and any period immediately following that day. The maximum period for which any woman shall be entitled to maternity benefit shall be 26 weeks, of which not more than 8 weeks shall be precede the date of her expected delivery. Lastly, the Sexual Harassment of Women Employee at Workplace Act 2013, one of the important act, and we'll just conclude the lecture after this act. This act prohibits any kind of sexual harassment of the women workers at workplace. This act came into force from 9th December 2013. What comes under this sexual harassment? A demand or request for sexual favors, sexually colored remarks against a woman, physical contact and advances, any other unwelcome physical, verbal or non-verbal behavior of sexual nature. This act has been implemented by public or private and organized or unorganized sector that have more than 10 employees. This act covers all women irrespective of her age or employment status. The fundamental point of the laws at work is to address the requests and the needs of the representatives. These laws really work towards getting particular changes, ranges like working conditions, wages, working hours, insurance of rights, and so on to representatives. So these were some of the important labor laws in India, which are to protect the employment and ensure good working condition, fixed working hours, fair payments, bonus and maternity leave, etc. to the people working hard, working at every level of different organization and contributing in the growth and development of the nation with full dedication, perseverance and motivation. Thank you all. Thanks.